I mean, doesn't Loper Bright wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context.
What did the Supreme Court hold in, was it Bureaucracy?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission.
District court rules in a case. You got plaintiff or defendant and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
Patriots, what we just witnessed is exactly why we fight. What we saw from Senator John Kennedy, once again, was a masterclass in holding the deep state and its administrative tentacles accountable. Loper Bright versus Chevron may sound like some boring law school case to the average viewer, but let me break it down in real terms. It's a seismic shift in restoring power back where it belongs, to we the people. This is Right View Nation, and today we're diving deep into why Senator John Kennedy is absolutely right to question the overreach of unelected bureaucrats, and why this Loper Bright case might just be the beginning of a new chapter in American liberty. First, let's talk about what Chevron even is. For nearly 40 years, this so-called Chevron Doctrine has allowed federal agencies to act like mini-governments, creating rules, enforcing them, interpreting them, and punishing anyone who disagrees, all without proper oversight. And worse, the courts just sat back and said, well, if the agency says so, that's good enough for us. That's not checks and balances. That's bureaucratic tyranny. The Supreme Court in Loper Bright said enough is enough. Agencies no longer get to interpret vague laws however they want. Courts now have to decide what the law means on their own. That's called de novo review. In plain English, no more automatic deference to DC pencil pushers. And it's about time. Senator Kennedy nailed it when he cut through the legal fog and asked the big questions. Like, why are unelected bureaucrats, who don't answer to voters, allowed to shape our lives, our economy, and our freedoms? Let me be crystal clear. The reason the radical left is losing their minds over this is because they've used the administrative state as their own private playground. Couldn't pass it through Congress? No problem. Just let an agency write a rule and punish Americans into submission. From the EPA attacking energy producers to the ATF going after law-abiding gun owners, this doctrine gave cover to unchecked tyranny. But now, the leash is off, and the courts are finally taking their job seriously. Now, one of the Democrats tried to play clever and say, but what about West Virginia versus EPA? Nice try. That case was a warning shot.
Tell me about the Loper Bright case.
Sure. So Loper Bright is the case that overruled the Chevron Doctrine. And the Chevron Doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron Doctrine?
Sure. So the court would originally make a step one determination about whether the statute was ambiguous or not. that's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
What's the relationship, if any, between Loper Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper Bright, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper Bright wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Bureaucracy, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Bureaucracy?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
My time is done. Thank you, Professor.
Okay, against my better judgment, Senator Schiff, I promised Senator Schiff, because I skipped him in order, I promised him one more question. All right, Senator. This gavel will never come to me again, though, if you ask more than one question. So we'll hold you to it.
Well, I've got the
This
gavel.
is
Well, there we go.
this is just in honor of Mike Lee's birthday.
Yeah, be sure I understand, Professor. District court rules in a case. You got plaintiff or defendant and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
So, of course, as a judicial nominee, I would be trying to
I
issue
don't want to
proper
split
orders.
hairs here.
No, the normal process is to
I know what the
seek
normal
appellate
process
review.
is. Can you
My-
think of any circumstances where you would tell the plaintiffs, nope, you don't pay attention to this federal judge?
So the problem with answering it that categorically is that there are potentially some very extraordinary situations you could imagine
Like
that
what?
could come before me as a
Like
judge.
what?
So this is a subject of
I'd be
tremendous
careful
scholarship.
there. I'd be real careful.
All right, Senator. All right. All right. I promised you one. That was 4, I think.
Okay.
See what you started, Adam.
It said that agencies can't make sweeping decisions on major political questions unless Congress clearly said so. But Loper Bright, that was the kill shot. And yet, the left is clinging to the major questions doctrine like a life raft. They still want to believe in a system where they can silence dissent, regulate you into poverty, and call it policy. Senator Kennedy saw right through it. Why do we need the major questions doctrine anymore? He asked. And he's right. When you strip away Chevron, the need for these backdoor legal maneuvers disappears. It's time we hold these unelected power brokers accountable in every single case. No exceptions. Then came the next bombshell, this whole idea of public rights. What does that even mean? According to these law school elites, it means if the government created the benefit, it gets to control how it's given out. So if you're fighting for your Social Security or a veteran's benefit, you don't get a jury, you get a bureaucrat. Let that sink in. Kennedy again pressed hard. What about when those rights start looking like private rights? Meaning, when the government starts acting like judge and jury on fraud or property cases, shouldn't we the people get a fair trial before a real court? Not some in-house agency judge rubber stamping whatever the regime wants. The Supreme Court just ruled that the Securities and Exchange Commission, SEC, another overgrown arm of the federal swamp, can't keep trying fraud cases in their own private courtroom. That's right. The SEC wanted to be the cop, the judge, and the executioner. No more. That ends now. And Senator Kennedy wasn't afraid to call it out. Because if we let them get away with it, they won't stop at Wall Street. They'll come for Main Street. And folks, here's the kicker. Senator Kennedy grilled a judicial nominee on whether there's ever a time when it's okay to ignore a federal court order. Sounds simple, right? Wrong. This nominee dodged, danced, and stammered, unable to just say what any real judge would say. Of course not. Instead, she babbled about extraordinary circumstances. That should send chills down your spine. If we're appointing judges who can't affirm the authority of our federal courts, we are handing over our justice system to activist radicals who will pick and choose when to follow the law, just like the Biden administration already does. Senator John Kennedy is one of the few voices left in the Senate who still speaks plainly, defends the Constitution fiercely, and exposes legal hypocrisy wherever it hides. He may speak with that Southern charm, but make no mistake, his cross-examinations are sharper than a bayonet. The fight over Loper Bright is about much more than legal jargon. It's about reclaiming our republic from the clutches of unelected power. It's about saying no to permanent bureaucracy and yes to accountability. And it's about time the American people had someone like Senator Kennedy asking the questions we all want answered. They may hate him in the D.C. cocktail circuit, but we love him in real America. Stand tall, speak truth, and never surrender to the swamp. This is Right View Nation, and we've got your 6.